The CPI report, Child Protection in Iowa, is brought to you by Vocal Victims of Child Abuse Laws. You can watch our program on Sunday afternoon at 1 o'clock, and again it's repeated on Wednesday evening at 9:30, all on Mediacom Cable Channel 15. You can email us at vocaliowa@mchsi.com. We appreciate receiving phone calls from parents that have a problem with the DHS. My number is 276-3956. John's number is 282-2672. My name is Don Burgmaier, and with me at the controls is my co-host,
John Harvey, and welcome to the CPI report. No, we're not lawyers, so we can't give you advice in the same manner that attorneys would give you advice. We've been in the business talking to parents and observing things that are happening in the court area for quite some time. In fact, we're going to have our court consultant back with us today. He's Terrance Walker. Terrance digs into the court sessions far deeper than we even do on our program generally. So we're going to hear what he has to say about what's happening on the court scene, and we'll be talking a little bit more about what's happening with the Department of Human Services. Well, a lot of things happening in the Department of Human Services. Some things happening in court, too. I think I've mentioned several times on this program that I was a victim of the court system and a renegade deputy. Not all deputies are honest. Not all deputies are kind. Not all deputies are knowledgeable of the law. And this particular deputy decided that he would hound me when I went in for extended media coverage. Extended media coverage means you've got a camera in one hand and lots of extension cords in the other. And he decided that he would simply hound me until such time as he could.
woof, 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 or arf, arf, arf,
Yeah.
or
And,
something like that.
He certainly was shadowing me, and he had no legitimate excuse for doing that. So we're going to probably be looking deeper into that particular question with respect to his business. And let's see, could this be something that you're looking for? Yep. Okay, good. Our consultant was looking for additional documentation, and it's a good idea to have good documentation when you come to a program like this. By the way, this is what we call a take one program. In other words, we start and 58 minutes, 30 seconds later, shut off the cameras, and that's it. No post-production editing. We do some pre-production planning in order that we can go 58 minutes, 30 seconds with our content, hoping that everything is in place by the time we get to that point in the program. Well, I want to tell you just how efficient the clerk's office is in the district court. I had one judge who was willing to disclose the fact that they are under-budgeted, understaffed, and that anything that happens in the courthouse is because they're under-budgeted and understaffed. Well, let's see what the story is here. John Harvey, just in the last day or two, got something called a final notice, and this is a final notice to pay off the fines from that criminal case that I had before the court. Let's see if we can find the word final. Yeah, I found the word final notice. Found the word final notice, and if they have a few suggestions of what to do if you don't pay your that final notice. Well, first of all, they can take your driver's license. They can refuse to renew vehicle registration. They can withhold Iowa state income tax,
Hold you in contempt.
hold you in contempt of court, take your firstborn son.
No,
That's
not in there.
that's not in there, was it?
But DHS is lurking in the background.
Sure. And garnish an execution of wages and assets. They can put a lien on your property. They can forfeit the money that is owed to you by the clerk. And, of all things, they can turn it over for collection by the county attorney.
Weren't you dealing with the county attorney in the court proceedings?
What? Say that again?
You were dealing with the county attorney in the court proceedings, weren't you?
Correct.
And so isn't that a conflict?
Well, not necessarily. They can have all kinds of threats here. Now, what they wanted $372. And let's see if we can find out how that $372 was handled. This $372 amounted to the penalty and court costs, and of course they wanted that I think by July 15th. Well, this check shows when they actually got the $372, and I think I'll be happy to show them. June the 23rd, 2004. Now they're just getting around to begging for that money again, and threatening to foreclose on my property and do all kinds of things in order to collect that money again. So if you don't have enough staff to do the work that you have before you, make sure that you make enough mistakes to make the situation even worse, not only for the people of Polk County, but for your workload.
Wouldn't it be easier, John, for the average person to receive that statement from the clerk of court and say, forget it, I've fought for a year, I'm just going to pay them,
Yeah.
get them off my back?
Well, in the meantime, I took this matter of Harvey versus State versus Harvey on appeal, and we proved to them what we had been saying all along, that they did not have jurisdiction to take this case to court.
What was your attorney's name,
And the
Mr. Harvey?
prosecutor knew that from the very beginning. But his job is to prosecute, not to do justice. And the judge in the appeals court
should be vice versa.
reminded him that's correct. He should be doing justice first, and then worrying about the scoreboard about how many wins and losses. And you had a question there, Don.
I was asking you what your attorney's name is, Mr. Harvey.
I did my own case. That's the only way I could afford to take this on appeal, is to do it on my own and to ask people who are knowledgeable in the law to offer suggestions.
You got any idea what it would cost you now to go get an attorney to fight this $372 that they're billing you repeatedly?
I don't know. They were somewhat cooperative. It took not quite as much time as it takes you on the telephone with technical questions, but they did finally say that they would send me a billing that said that the balance was zero. They said, we don't usually do that.
Oh, well, no, we want our money.
That's right. And I think they just got terribly confused because they billed me, they got their money immediately, and then they had to turn around and give me the money back because it was an unjust charge in the first place. It was an unjust prosecution, and I'm still out several $100s because I paid for the transcripts, the court did not. And we may have to take them to a small claims court or something in order to get the few $100s back for the transcripts. And I've shared those transcripts on the air. Maybe they don't like me sharing them on the air, but they're public information. Another thing that arose from this case and we'll probably be doing a little more talking about this. There is an organization called the Freedom of Information Council. And of all things, you would think that the Freedom of Information Council would be the first ones to say, let's roll up our sleeves. We're going to get behind Harvey on this one. He was, after all, he was on extended media coverage, and we should really pull together. The Iowa Freedom Council of Information Council is made up of a number of members of the larger media moguls here in the state of Iowa, the Waterloo stations, and the newspaper in Waterloo, the stations in Cedar Rapids, and the newspaper in Cedar Rapids, Council Bluffs, Sioux City, Des Moines, and so there are a number of people who subscribe or have membership in the Iowa Freedom of Information Council, and they have done some good things. However, I think they have really shot themselves in the foot on this particular case. Now, in each of the judicial districts, there is appointed an individual who coordinates the extended media coverage for the courts. And so that when somebody wants to do an extended media coverage, that is to shoot them either by still camera or by reports or whatever, then they take those they take their request to someone like Jeff Greenwood, and you may remember Jeff Greenwood as one of the reporters for KCCI Television Des Moines. Well, so whenever I want to do something in Boone County or in Polk County or in Warren County, I make my application to Jeff Greenwood. Well, here's what his request. Here's what his answer was to my request about a year ago now. Dateline April the 6th, 2004, Mr. Harvey. I apologize for the delay in my response, but I first needed to consult the Executive Secretary of the Iowa Freedom of Information Council, who was on vacation. I have received 2 requests from you. The first was a question about local expanded media coverage rules. I have attached a standing administrative order from Chief Judge Arthur Gamble issued March of 2000 regarding the additional expanded media coverage rules in effect outside of courtrooms at all 5th Judicial District courthouses. See, that wouldn't apply to me anyhow because I didn't intend to shoot any pictures outside the courthouses. Mine was within the courthouse. Within courtrooms, Chapter 25 of the Iowa Court Rules governs expanded media coverage, and you can access these rules that pertain to EMC through the Iowa Freedom of Information Council's website, www.drake.edu.journalism.foilfoi2 at HTML. Beyond EMC rules listed in Chapter 25, the judge's discretion over media conduct in the courtroom. Well, obviously, he should have control over that. Your second request was an EMC request for State of Iowa versus John Harvey, Polk County case number SMAC 264885. It is my understanding that this case stems from your arrest in the hallway of the Polk County Courthouse on March 24th, following a dispute with Polk County deputy over EMC rules over another case. Sorry, there was no dispute. There was no discussion about EMC rules with the deputy. The deputy doesn't have enough sense to hold a proper discussion. In 1980, the Iowa Supreme Court has allowed cameras in the Iowa courtrooms. I emphasize the word allowed because unfortunately neither the court nor the Iowa legislature has codified expanded media coverage as a right. In other words, this is a privilege that can be taken away. All you have to do is take a right, make it a privilege, and then you can tear up the privilege. I don't recall the first time you requested EMC several years ago, but I can share with you that it generated discussion. Now, isn't that interesting? I made an appropriate request, and that generated discussion. It should not have generated discussion.
Should have generated some action.
Yeah, it sure should. To the best of my knowledge, the Iowa Supreme Court never defined the phrase news media. In doing so, I believe there is a lingering questions regarding who may qualify. In other words, now you have to qualify to be a part of the media, the so-called media, because apparently this has taken on a new meaning somehow. In doing so, I have lingering questions regarding who may qualify to utilize expanded media coverage, and I've always taken the position that the Iowa Freedom of Information Council, which is charged with administering EMC, should define news media as liberally as possible and go beyond the daily television and radio newscasts and newspapers, although you are not conventional news outlet. I'm sorry, but the guy with the handbell that is passing out leaflets in colonial New England is a part of the media. He's getting out a message by one way or another, and so am I. I don't have to have a 50,000 watt voice of the Middle West, coast to coast television strength or radio signal in order to be a conventional news outlet. I have always advocated that you should be allowed to take advantage of EMC. That being said, I try earnestly to ensure that EMC programs in my region run as smoothly and obtrusively to the judiciary as possible. Before I switch pages, I'll read a footnote down here. There are more instances of the abridgment of the freedom of expression by gradual and silent encroachments of those powers than violent and sudden usurpations. That was written by James Madison.
Who is this from, John, and what date was that sent out?
Give me the question again.
Who's writing that and what date?
That was James Madison. Oh, the one that's writing the letter was April the 6th, 2004.
And what is his name?
Jeff Greenwood.
And he's head of the court media issues.
No, he's called a court. You need to get closer to your mic. He's in charge of. He's called a media EMC coordinator, and he operates under the auspices of the Iowa Supreme Court. Without passing judgment about your incident at the courthouse, by the way, Mr. Greenwood, my incident at the courthouse was overturned. This deputy from whom you got your information, apparently, was dead wrong. He didn't know anything about the law. And when he talks about having a dispute with John Harvey, he was dead wrong. I have serious concerns about allowing EMC for your criminal case. In other words, here is somebody who represents the freedom of information who is going to strangle the freedom of information. Can you imagine that? I believe it would draw unnecessary attention to the EMC program and potentially risk a setback to what I have worked hard for years to cultivate. For that reason, after consultation with the Iowa Freedom of Information Council Secretary Kathleen Richardson, I will not file an EMC for this case. You're somebody who loves freedom of information, but is going to take it upon himself to appoint himself as one who will curtail it. He's the coordinator. He's not the axeman in this situation.
And we're supposed to have a First Amendment right to public court hearing, right? Is that right?
That's correct.
So,
But
in essence, they're curtailing the provision of the Constitution that enables that, in essence.
correct.
To try to limit it to a certain select individuals who can deem whether or not you're worthy or not to come in there with the camera.
Right.
So, we have a situation right now where First Amendment rights don't mean nothing here in the Iowa courts, obviously.
They certainly have been unfortunately curtailed, and see, I was going to wait until after I had won my case before I even mentioned this, because until that time, anything that they would say down at the courthouse about struggling with me would, of course, be taken with would have some merit, right? But no longer is any discussion from the Deputy Duck down there valid, because Deputy Duck didn't even know the rules. He ducks the rules. I have serious concerns about allowing EMC in your criminal case. I believe it would draw unnecessary attention to the EMC program and potentially risk a setback to what we've worked hard to do for years to cultivate.
Well, I'm trying to figure out what is the reasoning used there?
I have no idea.
So you're not supposed to have your proceeding taped because they fear that they will not be able to have any future tapings? I don't understand what their reasoning is.
I think that he was feeling his oats at that point, and having been appointed by the Iowa Supreme Court, figured that he would carve out some kind of a jurisdiction for making judicial decisions. And I don't think it's up to a coordinator to make judicial decisions. If he didn't want me to do that, he probably should have gone to the clerk of the Supreme Court or to the chief judge of the Supreme Court.
It doesn't sound like a well-reasoned opinion.
No.
And in my opinion, it doesn't sound like it was one based upon all the facts. They didn't even lay forth any facts. And furthermore, they was going off of pure speculation and off the word of a few public officials in order to try to deny you further access to the courts and videotaping.
That's right.
And this is what we get. This is the kind of freedom that we have here in Iowa to tape the court proceedings, obviously. The officials feel it's their duty and obligation to shield the public from what really goes on, obviously.
Okay. But I think I have to applaud an organization like MediaCom for making this kind of access possible, because that is the nature of a public access station, to tell the truth, where the big media stations would not be interested in telling the truth. KCCI is not going to take on a case like this one. KCCI wouldn't give me the time of day. Yet it is a KCCI employee who is going to curtail my access to the media, and I think that is a.
And that's the essence, I feel, of a democracy.
Yeah, right.
Because we've got to have access to information. We've got to access to government. We've got to have public awareness of all that's going on within government. So, I mean, it just doesn't make any sense for them to try to curtail that and feel that there's some sort of justification behind that. You know, it just sounds to me like the court officials cornered him and said, "Well, we don't want to bring this out on TV because it might make us look bad."
Yeah,
you know?
right.
And I feel that it does make them look bad, because in one instance you have the deputy saying that a court official came after you because the judge said to escort you out of the courthouse, even though you had a legitimate court order to record the proceeding that you were there and to tape.
That's
you know.
correct.
So it's horrible.
For that reason, after consultation with the Iowa Freedom of Information Council Secretary Kathleen Richardson, I will not file a EMC for this case. This does not prohibit you or the public in any way from reporting on the substance of what transpired in your case. In other words, I can go down there and take notes.
Yeah.
And you can go down, Terrance, and you can take notes, and you can tell everybody in central Iowa, even though you don't have a microphone in front of you, even though you don't have any cameras available, even though you don't have access to what was actually said. And by the way, my camera...
But God forbid you have something that actually speaks for itself, like camera.
Yeah.
You don't have to tell the story. Your credibility is not an issue if you have a camera.
That's right.
I think that the thing that they were trying to do was prevent you from presenting that sort of clear picture to people that was unbiased of a videotape of the whole trial. You know, it's just ridiculous.
I don't
Again,
know.
I say.
I don't know if you knew it at the time, but the prosecuting attorney actually did write a motion of resistance against having this. Yeah, because it could be embarrassing. You know, when you're trying to pull off something like a violation or malicious prosecution or violation of Iowa Rules of Criminal Procedure, you certainly don't want to do it on camera. And this is what has actually come about. Well, I think he recognized that we were going to get it on TV one way or another. So, thankfully, a gentleman who has been in the media for some time, and of course he's probably not a part of the conventional media. He's just been on it, for 7 years and been publishing for some 18 years in a newspaper. Dave Leach did the media coverage for John Harvey versus the state of Iowa. Jeff Greenwood said, I am one of 13 coordinators, the final arbiters of the EMC program are Mrs. Richardson and the Freedom of Information Council Board of Directors. If you wish to pursue it, you may contact Kathy Richardson at 271-2295 or by writing her at the following address, and he gives the address. So after all that, saying, no, you can't have EMC, sorry about that. You're not going to bother us because after all, we kind of wondered about you in the first place. We kind of wondered if you were conventional media. Now KCCI, with its millions and its background, its place in the central Iowa, I suppose now they are conventional media. Well, I'm not sure that your standing is based on your size. I think we can tell the truth probably as good as or better than KCCI can tell the truth. Don, we're going to look at one of the stories. Did you have a comment on that?
Yeah, just one quick comment. Prior to this letter that you wrote out, you have went through with Jeff Greenwood for many years, haven't you? To
Correct.
Get extended media coverage with no problem.
And no one had ever said anything about not being media, conventional, not being conventional media. No one has said anything about generating discussion before this. It all came when the public officials of Polk County decided to make an issue out of it. And then the prosecutor said to the jury, this has nothing to do with EMC, has nothing to do with extended media coverage. Well, sorry about that, Justin Allen. It has everything to do with extended media coverage. That hound had no business following me simply because I had an EMC camera in hand. That fellow had no business arresting me, had no business injuring me, had no business depriving me of my freedom, simply because he made up his own mind that something was amiss here. Well, no,
Well,
I ain't going.
I think, and I hate to interrupt you, but I think he made up his mind to try to conjure up some sort of reason to arrest you simply because he may have feel slighted um, by your talking to him and telling him that you had a right to be there at the proceeding,
Correct.
and he feel that he probably should be an authority, and he's going to tell you what to do no matter what.
Correct. And that isn't the way it's been handled in days gone by. That doesn't mean that the court can't arbitrarily change its mind. But if it's going to change its mind, it ought to alert me. You see, Jeff Greenwood was the one who gave me the first inkling that there was such a thing as a 2000 ruling from Judge Gamble. Now, they should have passed that out to everybody. There aren't that many people who do media coverage in the county. But I've done media coverage in Story County, I've done it in Warren County, I've done it in Polk County before with little or no problem, and never with a court order. Now they're going to have court orders. They're going to even set it up so that it is not a continuing case. Well, Don, we have a new director in our area called, by the name of Rickman. She's one of the sweethearts down there at the Department of Human Services. Wonder if you have a story that tells about Wendy, I think her name is Wendy. Yeah, Wendy Rickman, quite an accomplished lady from Scott County. Would you tell us about what DHS is thinking about doing for Wendy Rickman come May of 2005?
Rickman is named DHS leader in Des Moines area. This comes from Roger Munns, who put out a press release. Wendy Rickman, a veteran social worker and manager of Iowa's redesigned child welfare system, has been selected to administer the Des Moines-based service area of the DHS. DHS Kevin Concannon and Rickman would begin her new duties in the 14-county area on May 2nd. She succeeds Dale Schmitz, who retired last month. Rickman currently holds a similar position in a 7-county eastern Iowa area centered in Davenport. In the short term, it was a hard decision applying for the Central Iowa job. There are a lot of exciting things happening in Davenport, and that's where I got my start. But in the long term, I have a lot of work left in me. I'm eager to have an impact in Iowa's largest service area, she said. Rickman, who earned a master's degree in social work at University of Iowa in 1996, entered the DHS as a child abuse investigator in Davenport in 1987. While based there, she held every social worker position in the department and was appointed by Concannon, Director Concannon, last year as project manager for the redesign of Iowa's system that responds to child abuse. Important components of the new system are being launched in March, including an experimental voluntary referral system aimed at helping families in which child abuse is a low but measurable risk. Most of these families do not receive services under the current system. Rickman earned a degree in social work from Carroll College in Helena, Montana in 1981 and a residential treatment worker in a Moline, Illinois home for disturbed teenagers prior to taking the state position in 1987. Concannon said a search will begin soon to find a replacement for Rickman in Davenport. I'm grateful for the opportunity, and I look forward to meeting with staff and all the community providers who make the Des Moines area Such a great place to work, she said. The DHS has 8 service areas, including those headquartered in Des Moines and Davenport. The Des Moines-based area includes Polk, Boone, Dallas, Adair, Madison, Warren, Marion, Adams, Union, Clark, Lucas, Ringgold, Decatur, and Wayne counties. Got a question, John? If a person has a complaint about how DHS is handling their case, is this somebody a person could contact?
I would think so, because she'd be in a supervisory position and in a position to wield some authority to straighten things out. If, however, you have problem with the Department of Human Services personnel, there is a fellow by the name of Jim Krogman that you should be contacting at an area code 515-281-3526. Don't bug him about any other questions, but if there's questions about the propriety of their work with the way a social worker does the job, then Jim Krogman is in charge of field operations, and he's the one to complain to about that particular thing. I'm not sure that Wendy Rickman, she's going to have some other administrative duties. She may not be able to hop on this one quite as fast as someone who was assigned specifically to field operations. Well, there's a gentleman that has been dropping into the studio several times talking about court, and the reason why we perk up our ears is because we know that there's not going to be anything done to improve the lot of for families unless the court situation is shaped up. And I think he would probably like to shape things up. Here now, Terrance Walker.
Hey, thanks for having me again, John. I can't help but to also say, and I'd like to relate this for the listeners, that everything that the courts do and the propriety of our court system wholly affects anything and everything that the DHS does, and as far as the citizens here in the state. They can limit the actions of the DHS by appropriate constitutional or statutory authority, or they could just enlarge the duties of the DHS. So it's highly paramount and essential that everyone pays special attention to what the courts are doing in this regard. I had a couple different things I wanted to talk about. One was an article that I've brought up before by a fellow by the name of Anthony D'Amato, and from the Cardozo Law Review. And we stated this in reference to your case when a judge misstated that the deputy that arrested you in that bogus case that was subsequently dismissed several months back. We used this article in discussing how the judge was wrong in actually taking this the facts at liberty, taking the facts at liberty rather than telling a flat-out lie, I should say.
Okay.
But Anthony D'Amato, in The Ultimate Injustice, basically states in this article from 1990, Cardozo Law Review, the ultimate injustice when a court misstates the fact. I'm going to paraphrase since we don't have that much time. He states partially, we must acknowledge that justice in any situation depends upon a full and fair accounting of the facts of that situation. If, instead of facts, fictions are introduced that are contrary to the facts, then any claimed just solution, in quotes, based on such fictions cannot achieve justice in the real world. The proposition is so elementary that it usually goes without saying. This simple hypothetical case that he's discussing in this article immediately leads to a deconstructionist-minded reader how does such a situation in a trial could ever come about in the first place. Wouldn't the police and state attorneys have interviewed the witnesses who established that the defendant was somewhere else when the crime was committed? Why then was the defendant arrested, indicted, and brought to trial. But in thinking through these possibilities, we must acknowledge our underlying assumption that the police and prosecutor are acting in good faith. If they are not, for example, the arrest and indictment of the defendant were arranged for political reasons, then such a scenario is indeed possible. We can also be perplexed about the trial judge in the case. Surely a trial judge would direct a verdict for the defendant as soon as the prosecutor's witnesses are at trial are established that the defendant could not possibly have committed the crime. Yet it is impossible to imagine that the judge was corrupt. Do judges routinely display a casual attitude toward the facts of a case? I suggest that practicing attorneys be asked whether they have had cases where the judge's statements of the facts were false. Every practicing attorney to whom I've asked this question has responded in the affirmative. And I think this is very important here. This is a law professor that wrote this article. He knows a lot of attorneys. And obviously, they all say that judges take liberty with the facts or otherwise change them. Some attorneys have told me that the practice is unfortunately quite common and that judicial misrepresentation of the facts of cases has produced a crisis in their professional lives. They feel that their work is subject to the whim of judges who play God with the facts of a case, changing them to make the case come out the way the judge desires. Some say that if they had known the practice of law would be like this, they would have gone into a different profession. Professor Monroe Friedman recently stated in a speech to the Federal Circuit Judicial Conference, "Frankly, I have had enough of judicial opinions that bear no relationship whatsoever to the cases that have been filed and argued before the judges. I am talking about judicial opinions that falsify the facts of cases that have been argued, judicial opinions that make disingenuous use or omission of material authorities, judicial opinions that cover up these things with no publication and no citation rules." Now, you might think, well, does this really go on? Well, I have a case that hits close to home that I can actually demonstrate that this goes on. This case has involved a fellow named Terrance Walker, myself. 1995, we'll go back about 8 years. And I'll paraphrase this since we don't have that much time again. I'll just state the facts of a case here. This case emanates from a hearing that took place about a subpoena in the middle of a simple misdemeanor trial. In an attempt to secure the witness on the day before the hearing, Walker signed the back of a subpoena directed to a 12-year-old Chance Bearden. The notary that notarized the return of service did not administer an oath pursuant to Iowa Rule of Evidence 5.603. Chance Bearden was not personally served by Walker that day. Chance was given the subpoena the next day by the daughter of his then-girlfriend. At the trial the next day, Walker presented the judge a subpoena directed to the 12-year-old. The court inquired as to his age. When further questioned about the adequacy of how he gave the child the subpoena, Walker stated that he merely wanted him brought in to testify. And the court denied the subpoena because Chance Bearden was 12 years old and his parents were not served a copy of it as required by court rules. And this is an actual excerpt of what Judge Van Merrill said. He's from Story County, by the way. "Well, let me call the school back and tell them that it will be up to them and Mr. Bearden's parent to decide whether or not they should bring him in here this afternoon. Then we'll have to get started again with this trial." Now, later, after this subject, Mr. Walker, myself, was arrested for the act of giving a subpoena to a minor, which was an invalid subpoena, the previous day, or the next day, the day prior to him actually signing that he gave it to the child. At trial in this matter, Judge Van Merrill testified that a minor's parents or guardians have to be served a subpoena. Now, interesting enough, in this court opinion here, this is a 1998 court opinion. This is a matter which was appealed all the way to the Supreme Court. You might want to put that on camera for the record. This is the 1998 court opinion by the Iowa Supreme Court, our trusted guardians here in this state for judicial interpretations. 578 Northwestern Reporter, second series of 280. If you're legally adept, you can look up cases and stuff like that. And if you don't mind, I was going to read a little bit more from that. The court, even though Walker was not given any sort of presentation of some of these facts in this court opinion, and you can go through the first couple pages there and show that they did not put these facts in this opinion. And furthermore, the attorney who represented me in that appeal in this matter did not even bother to contact me or consult with me as required by the Iowa Rules of Ethics for attorneys. And even the new ones that they're proposing, it explicitly states that attorneys are supposed to communicate with their clients. Well, I brought this fact to the attention of the Court of Appeals on a procedure known as post-conviction relief, which is after the fact proceedings, because the United States Supreme Court said, and matter of fact, it was just a few years ago, they basically said that if a person has a particular issue that they have an attorney forget to raise on appeal, they can raise that. And this case was decided in 2000, Smith versus Robbins. The Supreme Court affirmed the right to assert ineffective assistant counsel claims based upon the failure of appellate counsel to assert clearly stronger issues. Well, the Court of Appeals seemed to agree with that, and if you want to, I can show you this. You might want to put this on there. This is the Court of Appeals opinion. This was just announced February 24th, by the way, for all you people that can look up opinions online. The opinion is at judicial.state.ia.us. It's right on the web. You can look it up. If you can show that, I was gonna tell you how that they decided this. You see how they're? Do you have that on the camera? Is that on the camera?
What page?
On the first page, yeah.
Oh,
No,
okay.
that page right there.
We
That's
better,
fine.
yeah.
That's fine.
No wonder
As
you
you can
wouldn't
see,
follow
if you
it.
look at the top of the page,
Okay.
they discuss. They say, yeah, a person has a right to ineffective assistance of counsel. You can raise those claims, and and if you go down the opinion there, they say, well, that's fine, and they have to show that the attorney has to be deficient. If you go down a little bit further, they talk about briefly, very briefly. Walker first asserts the appellate counsel is ineffective and failing to communicate with him, master the record, and accurately cite the record. Now, they go on to summarize my claim. You notice they do not put any of the facts that were omitted, nor do they consider any of the facts in this other than to conclusively decide whether they are relevant or not. They don't even put them in the opinion. That shows you how they're omitting the facts that are supposed to be considered. And at the end of the paragraph of the page, moreover, to the extent the facts and arguments are relevant to the perjury and tampering convictions, they are either clearly known to the Supreme Court or have little impact upon the convictions. And if you look at the other page, they try to say that, oh, well, we can't consider these anyway because this is old. This has been decided. Even though the facts were not present in the beginning case. Now, you just listen to the absurdity of what they're saying. There's two contradictory positions. And this is a sort of thing that happens regularly in the Iowa Court of Appeals and in the Iowa Supreme Court. You notice they did not mention any of the facts that I've just laid forth, and you can go look at the Court of Appeals opinion. I'll give you the case number. It's 4-862, I believe. Terrance Walker versus State. You can look it up right online, and you'll actually see Now, at the bottom of this page, in the footnote, they say, well, when a claim in post-conviction relief is premised on ineffective assistance of counsel, the person must show sufficient reason for the failure to raise the issue. And a sufficient reason is provided by ineffective assistance of appellate counsel. You notice the absurdity of what they're saying. Now, if you look at footnote 3, if you want to know how a court contradicts itself, look in the footnotes. If you look on footnote 3 of this page, the next page rather, you will actually see how the court strikingly contradicts itself. Now watch. Now I'm supposed to show that the grounds that the attorney failed to raise were clearly stronger than the ones that were raised in the first opinion. Well, they said in the footnote 3, to the extent Walker is criticizing the Supreme Court's analysis in Walker 1, his contentions are without merit. Post-conviction reliefs are not a form of collateral attack on Supreme Court decisions. Once is procedendo, which is basically a filing that states that the appeal has been decided and you can go on with the procedure, the Supreme Court's opinion becomes the law of case. So basically they're saying, well, although you have a United States Supreme Court decision there that says that you have a right to have effective assistance of counsel on appeal, and if they forget to raise something, you can bring that up in a procedure known as post-conviction relief, but we're not going to decide anything against that opinion. Well, you know what? The Supreme Court, Iowa Court of Appeals, this is what I have to say about your opinion.
It does seem strange here.
That's awful strange.
It seems strange here that you're at one and the same time. We're saying that the counsel was ineffective, but he has to be totally articulate.
Yeah. Well,
In other words, he has to be able to explain things really, really well, even though he's ineffective.
Well, I don't see how you're going to bring up an effective assistance of appellate counsel here in Iowa, even though that's the United States Supreme Court's interpretation of our constitutional rights. The Iowa Court of Appeals and the Iowa Supreme Court appear to want to instead rule upon the merits of your claims. They want to instead justify the prior result. And that is not in any essence the same thing as deciding a claim of ineffective assistance of appellate counsel. Matter of fact, there's several courts, including the Supreme Court, that says that you must analyze the merits of both of the claims, the prior ones and the ones that are basically have been omitted from the original appeal. One other striking thing I'll point out here is there is also omitted from the opinion this is a statement. This is a statement, if you want to put that. This is a statement. This is actually from the trial court, the original trial court proceeding. This is a statement from the judge. This is in the transcripts. If you go down to the middle of the page, you see that little section that's by itself. This is trial Judge Rule in Story County. Oh, I remember the agreement you raised, Mr. Walker, and I will very candidly admit that there is a distinct issue in what the word falsify means in the statute that you have charged against you. I will candidly admit that there is an issue, an argument that falsify means altering a document, which I'll note that I did not do. And I understand evidence doesn't show that here, but there's another definition of falsify that might apply to the case. There's no Iowa appellate court decision that gives the court much guidance in that regard. So I candidly admit that you got an argument here. I just understand what you're saying, and you may ultimately be right. I'm not sure. Well, you know what? Iowa Court of Appeals and Iowa District Court Judge Rule, there is a provision known as the Due Process Clause of the United States Constitution, which there are plenty of precedences which you fail to cite in your opinion that explicitly state that when a citizen, if a citizen can be unsure about something, then it is, if something is not plainly and unmistakably prescribed, such as the Supreme Court decision of United States Supreme Court decision of Dunn versus United States, then you cannot use it. And if a citizen cannot be sure of something, then you cannot prescribe the actions of that citizen. And especially being as how a judge didn't even know what the heck the statute means, how do you expect a citizen to know what a statute means? It's just totally illogical. And I tell you what, moreover, this Supreme Court, this Iowa Court of Appeals opinion is appearing to put lipstick on a pig. All it did was basically justify the prior opinion. And look at that. There's one of the judges that issued the opinion. Judge Vogel, Judge Miller, and the other one was Judge Eisenhower. Well, guess what? Since you're going to put lipstick on a pig, so will I. Iowa Court of Appeals. And that's all I have to say about that matter.
Okay.
I think they look really lovely. Can you go back and pan on them again? That's Iowa Court of Appeals Justice Judge Vogel and Judge Miller and Judge Eisenhower. I tell you, they have a problem with reasoning there. Apparently, all their law school learning taught them was how to mistake the facts and justify the conclusion rather than to actually analyze things. I think they should have a philosophy class on analyzing skills before they proceed to practice in that regard.
Correct.
I will inject that that's the opinion of the guest and not necessarily the opinion of this program. Okay, John?
Okay. Is there, oh, you mean the lipstick on the pig?
Yes,
Oh,
the
okay.
guest brought that up.
Well, you've had some of those pigs around your plantation, haven't you?
Not when I was a farmer.
Okay.
Things were a lot nicer on the farm.
Okay. Okay. We want to thank you for your comments here, and sometimes you can be pushed into doing a lot more research when the case is against you. And I've had that opportunity to do that in working with Vocal and working with this cable outlet. Well, it looks like we're running short on time here, and we certainly appreciate when you tune in and also when you call in and consult with us regarding problems that you are having with the Department of Human Services. There are several stories that we would like to have gotten out. There's some statistics that have just been generated for year 2003, 2004, and there's been a case down in Winterset that is of interest. Tune in next